So here we are. Hello, dear fellow panelists and dear participants, and welcome to the DRBF Region 2 Connections webinar series Dispute Resolution and FIDIC Suit with Tanner Dedezade, Malith Mendes, and Don Rahukwa. I am Georgiana Takuch, President-elect of the DRBF Board of Directors Region 2, and I'm your host for today. For those of you who are new to DRBF, the Dispute Resolution Board Foundation was established in 1996 by the creator of the dispute board process with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has over 1,200 members from 97 countries, as the dispute board process has expanded worldwide and is now used on a variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners. It also partners with other industry organizations to adapt the DB process to new sectors. It may be of interest to note that DRBF is publishing a guide to best practices and procedures, the Dispute Board Manual, which is now available in English, French, Spanish, and Portuguese. Today's webinar is the second one and will address the dispute resolution and the FIDIC suit. Those of you who missed the first part, dispute avoidance and the FIDIC suit, could log on the DRBF YouTube channel, or if you're a member, access the library to view the recording. Our speakers will share their own experience from Africa and Asia in particular, but also from the rest of the world. We are booked for an hour, but we could stay a bit longer if you have many questions. Again, the recording will be available on the DRBF YouTube channel and in the DRBF library if you cannot attend past the hour. To introduce our speakers of today, Tanner Dedezade is a partner at Howard Kennedy, an international construction barrister, dispute resolver, published author, and world-renowned speaker. He's on the FIDIC president's list of the approved dispute adjudicators, a FIDIC certified trainer, and an ICC arbitrator. Tanner has won the FIDIC Trainer of the Year 2020. Malith Mendes is a chartered civil engineer with 40 years experience, a freelance arbitrator, a FIDIC certified adjudicator, and a FIDIC trainer. He is a member of the FIDIC certified trainer writing and examination committees. He was an examiner for the FIDIC certified trainer assessments in 2022 and a reviewer of the 2017 FIDIC contract. He's the chair of South Asia and Sri Lanka country representative of the Institution of Civil Engineers, UK. He has served in many standing ad hoc dispute adjudication boards and in arbitral tribunals. He's currently the chairman of consulting companies Maroc Limited in Singapore and Mendes Cobain Consultants in Sri Lanka. Don Rahukwa is a construction claims advisor in Botswana, focusing on both contentions and non-contentions construction and dispute resolution advisory services. He is an honorary secretary of the Botswana Institute of Arbitrators, an executive committee member of the Construction Adjudication Association of Southern Africa, and an executive committee member of the Botswana Association of Mediators, as well as a member of the Society of Construction Law, UK. And now, since we have done our best last time and yet have failed to avoid disputes, we have to resolve them within the framework of our FIDIC contract. So let's get started. Don, if you could hear us.
Yes, I can hear you, but I apologize. There's something going on with the camera, so I'll have to deny you the privilege of seeing my beautiful face.
And we know that you had a tie on earlier, Don, so we're denied the privilege of seeing you with your tie on as well.
Thank you very much for your kind words.
Don?
Yes, to kick us off perhaps we can start with just getting an understanding of what is a multi-tiered dispute resolution clause. It's also known as an ADR first clause or an escalating clause because they proceed from one stage to the other in a dispute in default of an accepted solution between the parties, moving between different techniques. So MTDRs invariably involve a series of steps in the overall dispute resolution process. And each MTDR stage usually contains different phases, each one independent of the other. For example, negotiation directly between the parties, mediation or expert determination, following which these phases then comes the formal and the last resort final phase, which is the invoking of the arbitration or litigation phase. In our last webinar, we were talking about dispute avoidance. In this one, we now are talking about once a dispute has happened and how we cannot put Humpty Dumpty together again. So we now get to the stage where there is a dispute. We're moving to the formal dispute resolution stage. Georgiana, over to you.
Thank you. So, Tanner, what about formal referrals? Let's get started.
Thank you very much, Georgiana, and it's an absolute pleasure to be here with you all today, and to have the opportunity to speak again with Malice and Don. It's a great privilege for me to be here in this webinar, and as Georgiana has mentioned, the topic that we are going to consider now is formal referrals. So we've managed not to resolve a dispute. So how do we go about issuing a formal referral to a dispute board? What should the process look like? What sort of evidence should be engaged? Would we be looking at expert evidence? Would we be looking at witness statements to be submitted? Will there be a hearing? Is it going to be a documents-only process? How should a hearing take place? Should there be inquisitorial? Should it be more of an inquisitorial process or more of an adversarial process? How should the hearing be structured? How many rounds of pleadings should there be? Should we have site visits? These are all the sorts of things that we're going to address in the first section of referrals. So let's start off with the situation where we've got a referral being issued by a claimant. Let's just assume for the purposes of discussion that, using an example, the contractor has a claim which has been rejected by the engineer, where it seeks both time and money. There are issues which are in dispute relating to the causation of various employer risk events that have taken place, and essentially we're dealing with a delay and disruption argument where we could have delay analysis, we could have quantum analysis to support our claim as contractors. And so we're at the point where we're going to issue as contractors a referral. So if a dispute board is already in place, a standing dispute board has been in place since the beginning of the project, then it may well be that the dispute board has already issued additional procedural rules for dealing with potential referrals. So that's one possibility. If it's an ad hoc DAB and the DAB is being constituted to resolve this formal referral, then at that stage that the ad hoc DAB has been constituted, then the first question that will arise is what should be the format and the process for the referral in terms of the documents, the experts' reports, the witness statements, and that sort of thing. And there are lots of different approaches. So one sort of approach is you have a notice of referral followed by a statement of case that's being issued by the contractor. Now, I've seen, going back many years, where the notice of referral will be issued and then there might be a 14-day period before the statement of case would then be issued by the contractor. And then after that, you get the process of the response to the statement of case. And then the question is, will there be a rebuttal or a rejoinder or both? So what I'm talking about is, how many rounds of pleadings should there be? How should we manage the 84-day period which is in place for the DAB to resolve this dispute? What is the most effective way of doing that? And should, for example, the DAB issue a process at the beginning? And if so, how should the DAB issue that process? So let's start off with what should happen at the point that the referral is issued. Let's assume it's an ad hoc DAB. And should the DAB have a case management conference to set off the process? Should they issue a written document which sets off the process that wishes to be followed in terms of the written pleadings and the expert evidence and the witness evidence? Why don't we start by kicking that about with Malice? It looks like Don seems to have dropped off. So Malice, what do you think? As a contractor, I've issued my notice to say that I've got a referral that I wish to refer to the DAB. As a DAB member, how would you deal with that, Malice?
If it's a stand-in DAB, then you already know parties and you have a formal communication system going on. If it's an ad hoc board, and assuming that the board has been appointed, what will usually happen is that you'll have a preliminary meeting where you call in the parties, and the employer can bring in the engineer as well. And the DAB has quite a lot of leeway in setting out the process, and of course subject to 84 days. Of course, different countries have different time frames. But the important thing is, when the DAB manages this process, is to ensure that adequate opportunity is given to the parties to present their case. That's the most important. Because that's also important when it goes to arbitration, and assuming there is a decision being made and you need to go to arbitration. Arbitration will look at whether adequate opportunity was given to the parties to present their case. That's the most important thing. So what you'll usually have is within that 84 days, time you'll decide at the preliminary meeting what is the time period within which the claimant will submit the statement of claim, and then agree with the respondent when is the statement of response going to be. Then you can have a reply to the response, and you might even have a fourth submission, reply, a response to the reply. That will all DAB will have to decide, and then decide whether you're going to have hearing as well. Hearing is also very important to ensure that the parties have an opportunity to present their case, and most of the time that's a good thing to have, because to be able to present something verbally can bring out some aspect of the case that you might not be able to present very well in the submissions. Then, of course, before the hearing, there might be site visits as well, which means that if you have a case of disputed physical conditions or disputed defects, or who's responsible for the defects, is the designers, is the contractor, the DAB might like to inspect that as well. So that will happen usually before the hearing, so that they can, whatever matters that came up during the visit can be discussed at the hearing. There might be expert reports or expert input required as well. So that also DAB will have to decide. Of course, it might mean that it will take more time to arrive at a decision, but it's very important that the dispute board examines all aspects of the case and gives rough justice, but good justice delivery to the parties. As you know, 99% of the projects in which there are dispute boards in place, it doesn't go into arbitration after that. It doesn't go on to the next year of dispute resolution. It's very successful in that way. And it's known as the success rate of the DABs. Also, I've heard from people that the times within which, where arbitration overturns the decision of the DAB or goes very far away from the DAB decision is very rare. So I think that way DABs are very successful. I heard a figure as low as 4% where the decision may be overturned in its entirety. So the DAB should attempt to lay it out in a way that within the 84 days you have all the information necessary to arrive at a recent decision. So that's the most important thing, Tana.
Okay, so let's pull that back and let's throw around a few different options. So my starting point was potentially that you give a notice and then there be a 14-day period before a statement of case be given. Do you think that's a waste of time? Or do we think that it would be better for the referral to kick off and the statement of case to be issued right at the outset, starting with that?
If it's a dispute, ad hoc dispute board, Tana, the timing for 84 days will start from the statement of claim. So that's when it starts the clock. So your 84 is from that day. So you might be able to have a preliminary meeting before that to decide what is the time period that the claimant wants for the statement of claim. You have to give them time as well. And the DAB might say what should be included there. If they are especially not used to a DAB being in place, and maybe not legal personnel of the contractor or the claimant being involved in it. So you have adequate time. Yes, the timing will start from the statement of claim. Okay. If it's a standing board also, yes, when you get a dispute, the statement of claim brought in, and then the timing will start.
Right. Okay. Agreed. So we want to have an adequate time period for the respondent to be able to respond to the referral. And we feel that the time should start from the moment that the statement of case has been issued so that there isn't any waste of time. So what happens in the 1999 form is that it may well be the case that there might be a huge, I mean, look at Georgiana. Behind Georgiana, the number of files that she has. These are the number of files for my referral. I'm a contractor, and the first 3 rows are my pleading, the second 3 rows is the delay analysis, and the third 3 rows is my quantum analysis. And that sets off the time running. And how long has the respondent got to respond to that? Because bear in mind, I've spent the last 2 years preparing this referral as the contractor. How are we going to give adequate time to the respondent to respond to that?
Should I answer or Don? Okay.
I don't know if Don heard all of that.
Okay.
Yes, indeed. That was the very point I was going to be making, Tana, that the claimant very often has a lot more time to prepare because he's had adequate time to actually put his case through the engineer and have the engineer's response. And so to the extent that one has to recognize that within the 84 days, in order to do justice between the parties, you've also got to give the defendant or respondent enough time to be able to prepare. Otherwise, you're just opening yourself up for claims that they've not been heard. So it's a fine line, but certainly one would want to make sure that the parties have participated in the process of actually defining what the rules of engagement are. Thanks, Tanner.
Okay, so let's assume actually, just before we move on to the next stage, some of you may not be aware that in the 2017 form, the problem that I've just described of a contractor having 2 years to potentially produce a claim to present to the DAB is not going to be feasible, because there is a mandatory period for a contractor to be able to start the dispute board proceedings within 42 days, which is only a 6-week period from the date it gives a notice of dissatisfaction in relation to an engineer's determination. So this sort of dynamic is not going to be possible under the 2017 form of an unequal amount of time, or a majorly unequal amount of time for a contractor to present its claim, and for so there'll be a smaller time frame. So going back to the initial discussion, if we've got the statement of claim in and we've got an 84-day period, that's 3 months. So the time starts running with the statement of case. How much of that 3-month period do we need to allocate to the exchange of pleadings? And when I talk about an exchange of pleadings, we also need to decide what goes in each round of pleading. So should the initial pleading that's issued by the contractor be pleading which includes delay analysis, quantum expertise, or any other expertise if there's a technical matter, technical expertise? And then should the respondent then respond with the relevant expertise, or is this all a bit too formal, and does this all sound a bit like an arbitration to you? So what do you think, Malice?
The statement, as you know, I mean, the claim would have gone through the engineer's process as well, and the responder would have fairly good knowledge of what the claim is. So they're not coming in, without any knowledge of what the claim is, so it should be an adequate amount of time so that you have, especially if the response will contain a counterclaim, to be able to respond to that as well with the reply. It's important that that adequate time is given, but not too much time. So usually it's about 2 to 3 weeks that you will give to the responding party to respond, to try and keep within the 84 days. But remember that the reply to the response from the claimant might require time as well, compared to if there's a counterclaim included in the response. So that is the way you look at it actually. But giving enough time for after maybe the reply for the DAB to ask any questions and see whether any expert evidence or expert reports are required for them to and also site visit before the hearing. So you will try and set out a program of within 84 days of having. If you would prefer to have parties also might prefer to have a hearing. So in which case, setting it out in a program on trying to giving reasonable time to giving them opportunity to present their case. Okay,
so I mean, should the time be carved up in the first instance by the adjudicator, the dispute board, deciding how long they might want to actually draft their decision? So in that sense, we knock off out of the 84 days a certain period and then share the rest of that period for pleadings to be exchanged, witness statements, expert evidence. What do you think, Don? How long do you think a DAB should need to have for their decision-making process? Do you think they need a month? Do they need 2 weeks? I mean, obviously, the more time the DAB has, the less time for the parties to be exchanging in pleadings or potentially for hearings and that sort of thing. So is that a good thing to start up with in order to determine how much the time frame should be split up? What do you think, Don?
Thanks, Tanner. In my view, at least, it is a relevant consideration, but really, it all depends on exactly, I think much of the time should be spent on identifying the issues in dispute between the parties, because that will often determine whether there will be the necessity, for example, to bifurcate and have a liability stage before the quantum stage, which would then simplify things. If it were, well, I don't know about simplifying things, but it would make things clearer, at least, if you had an end date in mind, to start off maybe by saying how long the DB will need in order to arrive at its decision. But that largely also involves a discussion around what are the issues which the DB will be asked to decide. Because let us not forget that the DB must decide on all of the issues that are in dispute between the parties, and a decision that doesn't do that possibly would not have met the parties' expectations. So for me, there has to be an indication of exactly what is the nature of the dispute, and if we can get quickly to the identification of the issues and whether there'll be a need to have experts involved, then it makes things much simpler, and the DB then can actually canvass the parties for the amount of time that will be left for their writing of the award. Let's always remember that the DB can always ask for more time from the parties, because it does allow them to ask for more time from the parties. Thanks, Tanner.
Thanks, Don. So I mean, in my experience, the parties can be quite difficult when it comes to extending the 84-day period. So there are two different types of parties. There are parties that are very much amenable to what the DAB might request. So a DAB receiving all the number of files behind Georgiana in the request might say, how on earth are we going to be able to deal with this massive referral in an 84-day period? And the DAB might say at the beginning, we've got so many documents here, I think that the respondent should be given a lot longer to respond, and we potentially would suggest that the 84 days be extended. In your experience, Malice, do you think that it's reasonable to extend periods in that way? And for how long would you extend a period? And do you normally have agreement between the parties for extending the time period of 84 days?
Yes, you have to have agreement. If one part does not agree, they might submit you a notice of dissatisfaction after the 84 days. And I have experience of that with a crisis situation where I was working, and the DAB members not being able to travel to finalize the decision. And also, if there are 3 members, it usually takes more time to arrive at a unanimous decision. And if you cannot arrive at the unanimous decision, then of course the majority who agree can ask the 3rd member to submit a report on his dissenting opinion. So remember, so it's all important. So it's very important that you try and stick to the 84 days, especially because you're trying to reach a quick decision. But if the parties agree, and that's when, if it's an ad hoc, a preliminary meeting is very important, then you can set the time, amounts of time given to each party, and that might go beyond the 84 days. But if they both agree and it's put down on paper, yes, that will work out fine. Those are the aspects of trying to extend the 84 days. Usually, if the DAB asks for more time to submit their decision, parties will usually agree, but you might always have the problem of one party not agreeing, and you have to be careful of that, where your all the work of the DAB will come to naught.
Okay, thank you very much, Malice. And let's go back to how do we issue our delay experts report and our quantum experts report, and if there's a technical experts report, a technical experts report. So Don, what do you think? Should experts reports be exchanged at the same time as the pleadings? So the statement of case has to come with the delay analysis and the quantum report. Any response equally would have a responsive report and or on any expertise which has been presented by the referring party. Or do we do something different? So the other option might be only specifying in the pleadings what the cases are, and then when the referral, response, rejoinder and rebuttal have all been issued, at that point we start talking about exchanging experts reports. I mean, that's the sort of thing an English court might do, but is that in any way appropriate for DAB proceedings? My experience is that the latter option is really not feasible. What's your position, or what do you think, Don? How does it work usually for you?
Well, my experience has always been that the DB is very often not delocalized from the rules of engagement or the rules of procedure, if you like. And ordinarily, the experience has been that you are required to put in with your statement of claim and your statement of defense all of the documents and evidence that you wish to rely on to sustain your claim or your defense. But quite obviously, at the person who is at the disadvantage is the respondent, because up until they know what the allegations are and what is being claimed, they would then not have already primed their expert witnesses, so to speak. So normally what you see is a reservation of rights to actually then engage those experts at a later stage, but only once the statement of claim is in. So to all intents and purposes, one would actually be looking at a stage after the exchange of the first round of pleadings, where you'd actually now know whether or not the respondent and the claimant want to actually then call in expert witnesses. But as we say, this can be quite difficult because we are under a limited time frame.
Thank you, Don. So
yeah, if I may add something there, Tanner. Yes, I mean, expert evidence or expert reports, like in arbitration, it can be party appointed experts who will give reports. And I would usually encourage reports rather than long periods of evidence being given. And then, of course, the DAB itself can ask, obtain expert input in. And I find that quite a lot of the time it might be delay analysis, it can be quantum, it can be even any technical thing. We do a lot of structural reports from third parties with the DB might call for. Of course, the parties will have to finance the cost of that, but it may be necessary to resolve the dispute at that point, to have some input of independent party giving this thing. So in arbitration, we call them dirty witnesses and clean witnesses. Clean witnesses being the tribunal appointed experts. That can be done too, especially if you have any of these problems that you need technical input or any other input in required to solve the problem.
That's very interesting, and as you've just raised it, let's kick that round a little bit more. So normally, the dispute board, if it's a dispute board of 3 members, might have an array of skills in each skill set of each DAB member. So there could be one lawyer, there could be a quantity surveyor, there could be an engineer. There may not be a delay analysis expert on the tribunal, but they've got all these other expertise on the dispute board. So to what extent should the dispute board potentially have recourse to a tribunal appointed expert or a DAB appointed expert? I mean, I'm using the word tribunal because this all sounds very much like an arbitration to me, because is it not reasonable? And in fact, we've got a question from one of our members asking about the fact that there are dispute board members that have got technical knowledge and experience. So in such circumstances, why would there be a requirement or a need for an independent expert? So what do you think about that, Malice?
Yes, I mean, the idea should be to use the DAB's expertise as far as possible. But it may be that the DAB doesn't have the expertise required to solve this particular problem. And the idea should be to solve the problem at this stage. And the DAB should call on resources as necessary to try and solve the problem at this stage. So, you might have an engineer, but he may not be a structural engineer, and he may not be a coastal engineer to solve the problem. So you call in expertise as required. So the DAB will have to decide that after discussion, whether they need external expert input. So that's something the DAB should, as they have the power within the contract to do so, use that to solve the problem at the DAB stage.
Okay, I mean, one of the other questions that I'd like to also raise, moving slightly away from that, is again going back to the process. Do we have, or is it optimum to have the opportunity for a hearing? And if there is a hearing, should there be a potential for the exchange of post-hearing briefs? What do you think, Don?
For me, the crucial question, Tanner, is what is the purpose of the hearing? Is it to receive evidence, or is it for the parties to actually present their submissions, which already are contained in the pleadings, and the adjudicator is aware of what is in the pleadings? So very often the adjudicator does have to tease this out from the parties to actually get an idea of what is the objective behind the hearings that they want. And if both the parties do say that we are in favor of a hearing, it's much more difficult for an adjudicator, I think, to say, no, I don't think so, because it's all intricately tied in with the fact that the parties must not only be heard, but justice must be seen to be done, not only to be done. So the process of hearing both parties sometimes depends on whether or not a hearing is actually given. And by a hearing, we're not actually saying an in-person hearing. It could be a hybrid hearing. It could be a virtual hearing. But I think the first question to be addressed is, what is the purpose for the hearing? Thanks, Tanner.
Okay.
Tanner, if I may add, I think the purpose of a hearing is, after hearing the presentation of the case by the parties, it gives an opportunity for the DAB to ask questions. And the three members might have different questions, which you cannot put down in writing and get it in writing. But it's always better. The hearing gives the opportunity for the DAB to ask any questions that they want, and to see if there anything that's still not presented to them. They want evidence of a letter that has not been submitted, some document that they require, and to be able to ask the parties to submit that as a final submission. Of course, the question comes after the hearing whether final submissions should be copied to the other party. I don't know whether you want to, we should discuss that right now, but the final submissions, whether they should be copied to the other party, is a question that comes up. So different DABs handle it in slightly different ways, but the hearing is, the parties can also ask for the hearing, in which case I think a DAB should allow that, because there is a provision to allow a hearing. So that hearing is for the DAB, opportunity for the DAB to ask questions as they want.
So running with that further, then I'm interested in that. To what extent, and this is about inquisitorial versus adversarial. So where you're interested as DAB to be able to ask questions of the parties, how would you structure a hearing then? Where the hearing's taking place, would you, for example, allow at the beginning of the hearing for the parties to perhaps have a presentation? Sometimes I've seen PowerPoint presentations being put forward. Sometimes the parties might want their potential witnesses to be called and potentially explored either in cross-examination or potentially being tendered for the dispute board to ask the questions that it wishes. There are a number of different things that different ways of structuring a hearing. What do you think would be the optimum way of structuring the hearing? Do we think that it would be useful to have an introduction where, say, for example, PowerPoint slides are presented by both parties? The reason why I ask is I remember very vividly speaking to a very senior judge who had experience as a judge and then also as an arbitrator. And one of the tips that he was giving to me as an advocate was, don't repeat the points that are in the pleadings if the judge or arbitrator or any dispute resolver has already got those points, because it's just wasting everybody's time. So as you said, the idea of asking questions is probably the most important thing for a hearing. But what do you think about the format of what should take place when and how in a hearing itself?
Okay, Tana. As far as I'm concerned, one of the ways in which you could structure it is the adjudicator could prepare a list of questions that are sent to the parties in advance of the hearing, and then the answers are circulated to both parties, and after that, then you have the hearing in terms of which then you are looking to clear up any areas that that have not either been answered or that the adjudicator wishes to get clarity on. That seems to be a way of curtailing the proceedings. And then you could also have the approach that uses what we call the chess clock rules. Basically, where both parties have an equal amount of time and they can use it howsoever they wish. Because that way, then you're not going to find one party saying, I've not had a disproportionate amount of time to make the presentation that I wish to make. Thanks, Tana.
Thanks. Anything to add, Malice, or should we move on to the next topic?
You can move on to the next topic, Tana.
Okay, so one of the things that I wanted to explore is, in the hearing, we've got experts and we need to examine those experts. A lot of people have heard of the concept of hot tubbing, where you put the experts next to each other and the experts are able to ask questions of each other. We've also got the traditional form of examining an expert witness by the parties in a more adversarial way, where questions can be asked by the party who is tendering the expert and then cross-examination by the other expert. So what are the advantages of hot tubbing over the traditional means? And which method would you prefer? Should we start with Malice?
Yes, I think the hot tubbing, just like in arbitration, is to see whether there are any areas in which they can agree. In which case, the DAB will have to deal with where they are not in agreement, and so the whole idea of hot tubbing is that. So then the DAB can decide: do we need to get their own experts, DAB appointed experts or expert reports that they need to have to resolve the dispute. So that's basically that, Tana.
Sure. Don, anything to add?
Yes, Tana. In my view, there's an opportunity for the experts, for the adjudicator to actually, with the agreement of the parties, of course, get like experts to have a joint meeting and then produce a joint report on the basis of which then you can then hot tub them on the basis of their having met previously. It doesn't help for for the experts to be hot tubbed in the middle of the hearing. It's actually a lot better if they could have met and agreed common areas, and possibly this could be done by way of a what do they call that? Oh, it slips my mind now, but there's a list of common issues and issues that they disagree on. A Scots schedule, perhaps, something along those lines. So the point I'm making is that it may be better to get the like experts to meet first and incorporate that into the procedure. Thanks, Tana.
Great. So here, let me set up a nice scenario for us then. We've got a contractor who has presented that second line of Georgiana's files as a delay analysis, and the employer has responded, and the contractor's delay analysis is a time impact analysis, and the employer has responded saying that the time impact analysis is completely useless, and they've put forward a completely different sort of delay analysis. We've got a DAB that are not specialists in delay analysis, and neither the analysis of the contractor nor the analysis of the employer makes any sense to it. So what should the dispute board do? Should they appoint a tribunal or a DAB appointed expert to come up with their own analysis? That's the first question. In fact, let me throw that to you both first. What do you think about that? How would they resolve that? Malice?
Yes, I think if it's such a complex dispute that requires complex delay analysis, then of course the DAB, if they don't have, and I think most of the time, usually they will not have the expertise to do all that analysis. In which case, they will get an independent expert analysis done by an expert. So that would be the way to go about it. Whether it should be after the submissions, wherein the analysis would be in the submissions or not, then the DAB will have to handle it however it comes.
Okay, let's change that scenario then. This time, the dispute board is a single dispute board member, and that dispute board member is an expert delay analysis person themselves. So they are experts in delay analysis, and they've got those two potential analyses that they don't agree with. And so is there anything wrong with the DAB doing its own analysis and then presenting that as part of its decision? And the reason why I raise that is that there is a case that I'm aware of in England where in an adjudication, a delay expert was invited by both the parties to accept their analyses, and they did exactly this. They said, don't accept either analysis. Here is my decision, together with my own delay analysis based on the information that I have. And the adjudicator did not give an opportunity to either party to comment on its delay analysis. And the courts in the UK criticised that. And they said, in the absence of the ability of the parties to comment on the analysis, that would be an inappropriate thing for the adjudicator to do. Imagine that was in an international setting. Imagine it was a DAB, and take into account one of the questions that we were asked earlier about the expertise of the DAB. Here we have an expert who is being appointed. Imagine it's an ad hoc DAB. The reason why the delay analyst has been appointed in the first place is because he's an expert in delay analysis. So any comments on that, Malice or Don?
Yes, Tana. I would agree entirely with the position that says that as long as the adjudicator has actually indicated that he is an expert to the parties, and both parties know that he's an expert in delay analysis, and also that his decision is going to be based on his own assessment or analysis. But if the parties don't know that, then that may be a problem, because at the end of the day, he's relying on something that has not been put to the parties for them to comment on. Thanks, Dan.
Anything to add, Malice?
Difficult situation, yes. I guess the best avenue to go about on this case would be for the DAB to do the analysis and get opinion from parties or to his analysis. He will have to, of course, also point out the weaknesses of either party's analysis as well, and why he's doing analysis himself. So I hope the parties will be amenable to the DAB member being an expert in the analysis and accept his decision. I mean, it's quick justice you are trying to achieve after all, something to be solved quickly rather than go on for years. So I would be very happy to have a DAB who is an expert in delay analysis. But I believe all DAB members should learn the basics of delay analysis, and I think that's a part of the training that if you do get into a DAB, part of the training that you must have. So they can do, it might be just a part of the dispute, and which the DAB might be able to analyze themselves.
Thank you, Malice. Moving on to another topic and picking up on something that you were saying earlier about whether or not the submissions should be simultaneous or sequential or simultaneous. So in a situation where, for example, we've had a hearing and something's come up in the hearing that the parties wish to put a post-hearing brief on, and both parties agree that they're going to agree on a round of post-hearing briefs, maybe one round of post-hearing briefs, and at that point, say the agreement is that 7 days after the hearing, both parties should simultaneously exchange a post-hearing brief. How should one deal with the simultaneous exchange, or would it be better to say to one party, you give your brief and the other party will respond? How would you deal with that? Malice, you want to start with that one?
Well, considering the time limit that you have in a DAB, what is usually done is the DAB at the hearing identify what should be contained in the final submissions. And they might ask the same questions or the same things by both parties. I find that whenever it's the documents are exchanged, the submissions are exchanged, then one party or both parties might ask for an opportunity to respond to the final submissions. And it might be a never-ending cycle of submissions. And we are trying to put a close to whatever they've been given adequate opportunity. Of course, they're given adequate opportunity. They would like to put a close to all the submissions. So you might ask that the same questions from both parties or the same documents to be submitted, or their attention to their opinions and their positions on some matter, but not copy to the other party. So that also happens in DABs to ensure that there's no challenge to the submissions, and then it becomes a never-ending cycle.
Okay, perfect. Anything to add, Don, or shall we move on to the next topic?
I think let's move on to the next topic.
Okay, so I'm not sure if we've given enough airtime to the site visit. You mentioned it earlier, Malice, but in what circumstances do you think it would be appropriate for a site visit to be used and at the same time as the hearing? Why would you think a site visit would help at the same time as a hearing, if at all?
Tana, usually the site visit will be before the hearing. It'll be where the case is regarding whether there is physical conditions that have caused a dispute, or it's defects that have caused a dispute. Those are the usual reasons why you would conduct a site visit. It might also be that both parties want a site visit, and then for you to get a feeling for the site, especially if it's an ad hoc DAB, feeling for the work going on in the site, or what has happened in the site, and physical conditions at site. So it's an opportunity for the DAB to to inspect something, but of course the evidence or whatever will have to be preserved, and it might be required for the DAB to say that those evidence be preserved, and then give an opportunity for DAB to decide whether expert input is required as well after the site visit, and then ask for that expert advice. And also gives an opportunity before the hearing, so going to the site visit, so that at the hearing you can ask questions as well regarding that site visit and whatever they inspected. So the site visit may be necessary for the DAB to derive a decision.
Mm-hmm. I mean, I've got a case at the moment where it deals with a water network which has already been completed, and there's nothing to see because it's all underground. The pipes are no longer visible, and there's nothing to see. So, I mean, in certain circumstances like that, I can see absolutely no benefit whatsoever in there being a site visit. But obviously, I think if the parties agree that there's something to see, then it's obviously potentially something to tie in. If there's going to be a live hearing at the project site, then it would make sense for the in those circumstances for there to be a site visit. But of course, one of the factors in whether or not to have a site visit is the amount of time that it takes, and or the cost that it will incur for that site visits to.
Yeah, I was in a road project dispute recently, and it was a matter of the compaction of the shoulders of the road, and that meant I had to travel kilometers and kilometers looking at the compaction of the shoulders of the road to be able to give my decision whether I need test reports on those things. So I can, it can be rather tedious, this site visit.
One of the
if I can just add, Tanner, that one has to be careful about site visits, because site visits, as you indicate, are quite useful to get a feeling for the site, what the conditions are, but it could turn into quite a fiasco with the contending parties saying, oh, look here, oh, look there. We had a site visit on one airport project where the dispute was about whether the airport had been completed. And when we went on the site visit, the DB members had to crawl into the roof void to actually see whatever they needed to see. And then, as an aside, those who were attending the site visit said, be careful of the snakes, because there's a lot of very dangerous snakes in there. And none of the DB members was prepared to go into the roof void. So it defeated the purpose of the site visit.
Absolutely. I mean, these you make some many good points, and in the sense that one of the things that is desirable when there is going to be a site visit, for example, with a road project, is in advance of the site visit, you identify those areas that both the contractor and the employer identify those areas that they wish the DAB to see. Because if that's not done, and that there's no discipline in the way that the site visit is structured, then that can be a problem. And it reminds me of years ago when I was dealing with a case where I was driving to a particular site, which was a road, and the drive was very smooth until suddenly we got onto the site of the road that was being constructed by the contractor in that particular claim, and then everything started getting very bumpy. It was like this was the road that we were then having to deal with. Okay,
yes, and you got to discourage them arguing while at the site visit as well, because that can go on for hours.
Sure. I'm conscious of the time, and there are a few questions that
yes, just before we go to the questions, just a quick mention for Vinod. A big part of your questions are dealing with dispute avoidance, and we have dealt with it in our past sessions, so please watch the recording. A second part is that a second note would be that we refer generally to both 99 and 2017 editions, so not only to standing, but to also ad hoc dispute boards. And I hope that gives part of the answers. I think I would like to go first with Sazakian question. What is the minimum number of hearings per claim? First question. And the second one, what is the minimum claim value for hearing?
I mean, I'm happy to take that first question. There's no minimum anything. I mean, ultimately, it needs to be a decision that's made, hopefully, consensually by the parties. And if it's not consensual, then the DAB makes the decision. I mean, ultimately, if it's not cost effective to have a hearing because it's a very small amount that's in dispute, then no doubt the parties will have tried to engage in dispute avoidance, and failing that, they might have agreed to have the matter dealt with on the documents only. But there's no, I'm not aware, at least, of any specific guidance on those questions.
Yeah, to answer how long or how many days the hearing should be. Usually, it's one hearing. It might extend over 2 days, but the DAB will have to manage the hearing very well to ensure that whatever they require is delivered and is accepted at the hearing. So DAB will have to manage that. This is not arbitration where it goes on for several hearings.
I mean, that's something we never managed to get round to discussing, which is in the 84-day period, how many days should be allocated to a hearing. And as you just mentioned, maybe 1 or 2 days. I've never seen in a dispute board more than, I think the longest I ever had was 2, and it ran over to the 3rd in the morning. So I think I saw 2.5 days, but that's very unusual. Usually it's 1 day, exceptionally 2 days, and that's normally enough. I don't know if that's the experience of all of you, or whether you have different experiences.
Tanner, I thought we had a couple of 3 days. A couple of hearings with 3 days.
3 days. I can't remember maybe 3 days, but definitely not more than 3 days.
No, not more. No.
Don, you have
But in deciding whether you're going to have however many days, one of the experiences I've had is that where it's an international DB and the DB members are coming from far away, it's better to budget for more days and then not have to use the other days than to under budget for them. So what we've normally done is budgeted for 2 or 3 days maximum, but I've never seen a DB that's budgeted for more than 3 days. A hearing, that is.
Yep. I have a question before we go to Gulam. For one of Vinod was asking, and few participants agreed, DABs are meant to be ADR methodologies for expeditious disposal. Is there a need for experts, their cross-examination and long-drawn legal arguments? Would it not make the DAB more like litigation and defeat the purpose of the ADR? Who would like to go first? Malith?
Yes. Well, DB will have to manage that to ensure that there's no unnecessary time taken in presenting expert evidence. So they'll have to decide, is it going to be in a report form, which they can study at leisure, or if they do want to have any questions, then they'll have to manage that. Yeah, to try and ensure that it's expeditious arriving at a decision. Yes.
Thank you. Tanner, what about this one from Gulam for you? If constitution of a dispute board is under dispute among parties, does it mean there is no DB in place and any party can initiate arbitration under the FIDIC Pink Book 2010?
Well, I think the position is the same in the FIDIC Red Book as well, 99. I mean, ultimately, this is a question of how do you engage subclause 20.8? And subclause 20.8 is the clause that says if a DAB is not in place for, I think the words, let me just get I've got the Red Book in front of me just to get the exact words that are used. If a dispute arises between the parties in connection with or arising out of the contract or the execution of the works, and there is no DAB in place, whether by reason of the expiry of the DAB's appointment or otherwise. So the problem is that the words or otherwise make it basically for any reason whatsoever, if there's no DAB in place, can a contractor bypass the dispute board and go to arbitration. So This is an interesting question, because in the Yellow Book, by definition, no DAB is in place at the point that the dispute arises. And yet 20.8 exists as a provision where you can go directly to arbitration. And so this was a matter that came before both the English courts and also the Swiss courts. And both the English and the Swiss courts took the view that a central mechanism in the multi-tier dispute resolution process was the dispute board, and that it would be appropriate for the parties to seek to constitute the dispute board prior to going to arbitration under subclause 20.8, and that it would be inappropriate to go directly to arbitration under 20.8 if the parties have not tried in the first instance to get the DAB in place. The problem with both of those cases is it's not really clear how long the parties need to try and how far they need to go, because at some point it will be the case that an employer, for example, is not engaging in the process and doesn't want to constitute a DAB, and 20.8 is the escape mechanism, if you like, the release valve that allows that contractor to go straight to arbitration. So to what extent does the contractor have to get the DAB in place? How many years, if we're talking years, or how many months? It is a bit problematic. I mean, the problem isn't so acute under the 2017 form. It's been addressed, but I think I've said enough so far, but it's a complicated issue.
Okay.
If I may add something, if one party is not cooperating in constituting the DAB, the contract has provision for the appointing entity to be requested by a party, and then a DAB will be appointed. So whether it's a member or single sole adjudicator or a single member or the chairman, there's always provision to go back to the appointing entity to get the DAB constituted.
And then that adds a next problem, another layer to the problem, because the wording in the contract under 20.3 talks about the appointment of the DAB by the appointing entity being final and conclusive. In what circumstances is it necessary, if at all, for the DAB to sign the tripartite agreement following the final and conclusive appointment? There are two schools of thought on that. One school of thought is that a dispute board is a creature of contract and has no powers absent a signed dispute adjudication agreement. And the other school of thought is that because of that final and conclusive wording in subclause 20.3, that in itself amounts to an agreement between the parties that dispute board would be in place. So it's not clear. And again, 2017 helps.
You mean like a deemed DAB agreement? Though there have been situations where, after all that, going ahead with a deemed with the appointing authority, appointing letter and everything being final and conclusive, where at the very end, the DAB has only been paid the 50% share of the fees by the contractor in that specific case, with the employer saying, we didn't want it.
Exactly, Georgina. That's the point, really, isn't it? Because most DB members want to know that they're going to put in this work and they are going to get paid at the end. So the nomination, the default nomination, is purely that I'm just nominating, but I'm not responsible for the payment of the fees of the DB. It's not an administered adjudication. So there you are.
Okay.
If I may add something, I think ADB World Bank has dealt with this. They do say the new contracts do say that the appointing entity will describe or specify the payment to the DAB, and World Bank and ADB make sure that the DAB is appointed before the notice to commence as well. So there are
Development Bank.
Pardon?
You mean Asian Development Bank in this specific specific case?
Not Asian Development Bank, World Bank and AIIB and African
Oh,
Development
okay,
do have it.
okay.
Yeah,
Because
yeah.
the case I was talking about, it's saying that funding is not available for that. Anyway,
The 2017 form has
no, this is the old form. Yeah, under the old one. Vinod still has a couple of questions that I would like to go through, if possible. So one of them would be, so not the first one, he said, standing DAABs are meant to avoid disputes. Can the DAAB actively participate in avoiding disputes, or should the parties use the DAAB meetings to do so?
So I think that whilst it's, that's the topic of dispute avoidance, but ultimately my view on that is there shouldn't be any prescribed form. It depends. My favorite words as a lawyer, it depends. But ultimately, the reason why I say it shouldn't be in a prescribed form is that sometimes, and this is something we raised last time actually, sometimes if a DAB explicitly has times which it has to deal with these things and or potentially raises these potential issues, then it can potentially be promoting disputes rather than avoiding disputes. Sometimes it will make sense at the site visit for the issues to be explored, which are candidates for dispute avoidance, and carefully crafted questions by the DAB on all the issues which might potentially lend themselves to dispute avoidance is appropriate, but there is no one size fits all.
Thank you, Tana. Barry has a question. Should the chairperson of a three-party board be required to be of a nationality other than either of the parties? I think here the answer is, whether it's private or public project. And Don, would you tell us for a public project, please? What is your perspective?
Sorry, can you just repeat that again? It was garbled a
Should
little
the
bit.
chairperson of a three-party board be required to be of a nationality other than either of the parties?
Well, to the extent, as the rules of engagement or the procedures would generally spell that out, but generally speaking, it would be desirable that you do not have issues of nationality coming into play whereby the perception can be that a DB member who is the same nationality as that of the chair, for a three-panel DB, it then lends itself to the perception that there could be collusion between the two. But as DB members are very often very ethical people, that shouldn't arise. But in World Bank-sponsored projects, it is very common to actually have that stipulation made in the procedure.
In the 2017 contracts with the Multilateral Development Bank special provisions, they do specify now the DB members have to be from a neutral country, not from the contractor's country or the employer's country. Whether the implementing agencies do implement that, we are yet to see.
Georgiana, if I'm not wrong, I think the DRBF handbook talks about the neutrality of DAB members, and my recollection is that in that DRBF handbook it does not stipulate it as an express obligation of the parties to have a neutral third party. So it's interesting.
As I said, private projects versus public entities and public funds. Yeah. One question from Roxana Lourdes. If the parties are in agreement, can the 84 days be reduced? I mean, make a procedure to get the term reduced. I would obviously...
Parties can agree anything. If they want to agree a 10-day process, they can have a 10-day process.
Yes, but would realistically an ad hoc adjudicator be able to deal with all that in 10 days or not? So I think it depends.
If the parties want to agree a 10-day process and the adjudicator doesn't like the idea of a 10-day process, then the adjudicator can decline the appointment. But obviously an adjudicator is not going to be expected to create anything magical in 10 days. So probably 10 days is inappropriate, but there isn't in principle any reason why the parties can't agree on any process that they wish, in my opinion.
Yeah, it's up to within 84 days, so it can be less than that. But you must understand that some of the statutory adjudication, like in the UK, it's 28-day decision in 28 days. So, you know, it's quite rushed.
A question from Joe Kelly. In relation to where a DAB is not in place when a dispute arises, in one contract where I was approached as a party arbitrator on the 99 FIDIC, where there were no amendments, no DAB was in place, would the DAB have to be formed, decision made before arbitration is commenced?
Well, I think we've kind of dealt with that, haven't we? I mean, ultimately, the process is that the dispute board is the first point of call before going to arbitration. And you need, as I was saying in relation to the Peterborough case, thank you, Eugenio, for writing that in. That's the English case that I was talking about. And there was a Swiss case, I can't remember the name of that one, but the position is that you need to go to the DAB first before you go to arbitration. And then the question is, if you don't go to the DAB first, then what? And is the arbitral tribunal seized? In other words, does the arbitrator have jurisdiction over a dispute in circumstances where one of the parties has opted to bypass the dispute board? Or is the failure to comply with the contractual process something other than an issue of jurisdiction? And this is something which has been explored there was a case in Hong Kong recently where, and I think this is an even more recent case than the Hong Kong case. I think that the approach has been that this is a question not of jurisdiction, but this is a question of admissibility. So the arbitrators are able to potentially dismiss a claim if it hasn't gone through the dispute board, but they have jurisdiction to deal with that issue. So it's an interesting question.
Some countries may have legislation that says the condition precedent to arbitration has to be met. So when it's dispute board or mediation, the process has to be done before coming to arbitration. And the arbitrators will be quite happy to throw out the case if they think that the condition precedent has not been met. So that happens as well.
Especially when one of the parties is continuously trying to boycott the appointment of the DB. And speaking of a DB appointment, Patrick Kane has a question about a situation where the appointing entity is a government organization and the employer is also a government organization. What is the position with appointment of the DAB? Before answering, Patrick, is that a common law country or a civil law country, out of curiosity? Okay, until we get a sign from Patrick, who would like to go first? Malith, you would have had this experience where a government organization is the appointing entity?
Yes, if the contract specifies that a government entity, which is usually a construction authority, is the appointing entity, then it usually goes ahead with the appointment, and then the parties agree to that, especially because the construction authority has so much of power concentrated in its hands that you have no choice but to agree to the government organization appointing the DAB.
I mean, the dynamic's a nightmare. I mean, I've had a situation where the CEO of the employer's organization is the one that decides who the DAB member should be. And in fact, it backfired on them, because ultimately what happened is that there were all these old government employees who had been working for the employer, and the employer thought that they would come to decisions in favor of the employer. But in fact, they couldn't stand working in this particular government organization. So they gave all the money to the contractor.
Okay, well,
I've even seen the secretary to the ministry is adjudicator.
Okay, Patrick just mentioned that it's common law country, so interesting. A question from Kasim. I think there is a condition that, quote, the DAB shall propose, unquote, the time other than 84 days first. See fourth paragraph of the subclause 20.4 FIDIC. And question is, oh, it is in relation to the previous Roxana's
Question.
comment. Okay. Kasim again. So shall the DAB have the right to fix the time at minimum 84 days? Comb brackets, that resignation, close brackets question. I'm sorry, Kasim, I'm not sure I understand what you mean, the connection between minimum 84 days and resignation.
I'm slightly lost, and I have to say I've got to go in about 3 minutes.
Well, let me check if it's any other question that I have missed in the chat or in here.
I've
Oh,
noticed that
resignation. Okay.
I've noticed that Chadash says that he loves me, so I have to say I love you too.
He left already. He had to go. He said he's loving you, irrespectively if you talk about the 99 or the 2017 edition. Well, I would like to thank everybody for being with us here today, and to our speakers for participating. And we have a surprise that next year, on 1st of February, we are going to continue in the same formula and look at the understanding the engineer's role and dispute avoidance and resolution under the FIDIC 2017 edition this time. So thank you very much for being with us today. I will invite you to come to our DRBF annual Central Eastern European Conference next year, 13th to 15th of March in Sofia, Bulgaria. And a special surprise for the end of year for our members, and a webinar, a complimentary webinar, mock DAB on 2017 on 21st of December. So please check our website and register on the calendar for that. Thank you very much indeed. Tanner, Malik.
Thank you. Bye-bye.
Thank you very much.
Thank you very much.
Bye-bye.
Thank you. Bye.
Thank you.
Bye.
Bye-bye.
Bye.